Have you ever found yourself in a tricky disagreement and just wondered how it might get sorted out without, a full-blown argument?
Happens all the time, doesn't it?
Yeah, from that classic family squabble over whose turn it is to do the dishes, maybe, to a tricky disagreement with a colleague at work, or even those huge challenges between massive companies. Conflicts are just, well, everywhere.
You really are.
But how do these really get sorted, especially when they don't end up in some dramatic court battle? It's a really interesting question, I think, and one we're about to dive into today.
Yeah, and what many people might not realize is that there's this whole um, increasingly common world dedicated to sorting out these civil legal disputes outside the traditional courts.
Right.
This is what we call alternative dispute resolution, or ADR for short. And it's not just some passing trend. For the last, say, 40 to 50 years, we've seen really significant sustained growth in using these other methods.
And that's exactly our mission for this deep dive. To unpack the world of ADR, we want to explore its different forms, understand the powerful reasons behind its massive growth, and uncover its surprising advantages and, yeah, some potential pitfalls, too.
Definitely pitfalls to consider.
We think this deep dive will give you a real shortcut to being, well-informed about this really vital and evolving part of our justice system. Okay, so let's begin with the basics. What is ADR, really? One of the first things that struck me looking into this is that even defining it isn't totally straightforward.
No, it's true. There isn't one single definition everyone agrees on.
But our sources point out that if you look at key legal glossaries, they often describe it something like a collective description of methods of resolving disputes otherwise than through the normal trial process. Kind of wordy, but
It is a bit, but that simple description actually highlights its core features.
yeah.
ADR methods are generally, much more flexible than strict court rules. They're really focused on finding practical solutions. Solutions that work for everyone involved, rather than just deciding who was right or wrong in a legal sense.
Solution focus.
Exactly. And you'll often find these processes are led by specialists in the actual subject of the dispute, not necessarily generalist judges.
Right, subject experts.
Plus, they're typically confidential, which is a huge plus for parties who want to keep their business private.
Yeah, I can see that being important.
And often, frankly, they're just less costly than going all the way to court. And there's a bigger picture, too. They help take some pressure off our, well, often pretty overburdened court system.
Okay, that makes sense. But before we get into how ADR grew so much, let's touch on something you mentioned, the name itself, that word alternative. It's actually come under a bit of fire, hasn't it?
It has, yeah. Some people argue it unfairly makes ADR sound sort of secondary or less important than traditional court battles.
Like it's plan B.
Exactly. But you have influential figures like Sir Geoffrey Voss, the master of the rolls, pushing back quite strongly. They argue that maybe litigation should now be seen as the alternative.
Oh, interesting. Flip it around.
Flip it completely.
Yeah.
This isn't just playing with words. It suggests a really fundamental shift in thinking about our whole legal system. Like a quiet revolution suggesting litigation, with all its cost and formality, should be the exception, not the rule.
Wow. Okay. That perspective really helps understand why ADR has grown so much, especially here in England and Wales.
It's key. The rise of ADR wasn't an accident. It was a very deliberate journey, driven by reformers and landmark legal decisions that basically forced everyone to rethink how justice is delivered.
How so? What were the drivers?
Well, it really kicked off with key reports, like Lord Wolfe's back in the 90s, identifying major problems with the court system, the huge costs, the long delays, the complexity, just how uncertain trial outcomes could be.
Right, the access to justice issues.
Precisely. And those findings led directly to things like the Civil Procedure Rules, the CPR, back in 1999.
And how did those rules actually push people towards ADR? Did they make it mandatory?
Not mandatory, no, but they strongly encouraged it. The CPR explicitly told parties to consider ADR first, Rule 1.4, for example.
Okay.
And it even allowed courts to pause cases, put them on hold, specifically so parties could try ADR. The message was becoming clear. Litigation really should be your last resort.
Just a strong suggestion then.
At first, yes. Then came more reviews, like Lord Jackson's, focused specifically on cutting the rising costs of civil litigation. ADR was a central recommendation there.
Right.
He even called for a serious national campaign to educate everyone, lawyers, judges, the public, small businesses, about why ADR is beneficial. And that led to things like the Jackson ADR Handbook.
So education was part of it too.
A big part. And then you had legislation like LSBO in 2012, the Legal Aid, Sentencing and Punishment of Offenders Act. That brought in huge cuts to legal aid.
Ah, so less money for court cases.
Exactly. Which naturally pushed more people to look for cheaper ways to resolve disputes, like ADR.
It's really fascinating how the court's own views changed through all this. It seems like they went from just suggesting ADR to actively, well, pushing it.
Actively encouraging it, yes. And in some pretty notable cases, even penalizing parties financially for refusing to give it a go.
Really? Penalizing them.
Absolutely. You could see this shift in cases over the years. Early on, maybe just gentle encouragement, like in Barker v. Johnson, urging neighbors towards ADR for greater happiness.
Okay.
But later, you get cases like Dunnett v. Railtrack. There, the winning party, Railtrack, was actually denied their legal costs because they'd flat out refused to consider ADR earlier.
Wow. Even though they won the case?
Even though they won. That sent a powerful message.
I bet.
But probably the real landmark case, the one that crystallized this shift, was Halsey v. Milton Keynes General NHS Trust in 2004.
Halsey, okay. What did that establish?
Halsey really shifted the burden. It basically said, if you unreasonably refuse mediation and then you lose your case in court, you'll have to convince the judge that mediation wouldn't have stood a reasonable chance of success anyway.
So the pressure is on the loser who refused ADR.
Exactly. It also clarified things a bit, saying, look, just believing you have a watertight case isn't necessarily a good enough reason to refuse mediation if that belief isn't reasonable. But if your belief is reasonable based on the facts, that might justify refusing.
So it's not forcing everyone, but a very strong nudge.
A very strong nudge. But Halsey also touched on a really important point you raised earlier about forcing people.
The right to a fair trial. Compulsory ADR.
Precisely.
Okay.
The Halsey judgment itself suggested that forcing unwilling parties into mediation could potentially be seen as an unacceptable obstruction to their right to access the court under Article 6 of the European Convention on Human Rights.
Okay, so a potential conflict there.
A potential conflict. However, things have moved on. A really significant report came out from the Civil Justice Council in 2021, specifically looking at compulsory ADR.
And what did they conclude?
They concluded that compelling participation could actually be lawful, but only under certain specific conditions. Well, things like ensuring the ADR options are affordable, that the process is proportionate to the dispute, and crucially, that parties still have the option to go back to court if the ADR doesn't work out.
Right, so the door to the court isn't completely shut.
Exactly.
Mm-hmm.
It really highlights this ongoing tension, doesn't it? Between wanting efficient resolution and needing to protect fundamental legal rights.
It really does. Okay, this is where, for me, it gets really interesting. Because when we talk about ADR, it sounds like one thing, but it's not, is it?
Not at all.
You mentioned a spectrum earlier. Could you unpack that, like a line with different options?
That's a great way to think about it. Imagine a spectrum or a continuum. On one end, you have completely informal, totally flexible ways of talking things through. On the other end, you have highly structured processes that result in legally binding decisions.
Okay.
ADR covers that whole range.
Yeah.
And we can sort of walk along that line, starting at the most collaborative, least formal end, negotiation.
Negotiation, right. We all kind of do that from childhood, don't we? Trying to stay up late, get an extra biscuit.
Exactly. We learned it early. It's the most informal, most flexible ADR process. Often the very first thing people try. Just the parties, or maybe their lawyers, talking directly, trying to reach an agreement.
And the advantages seem obvious.
They are. It could be quick, it's usually inexpensive, it's private, and crucially, the parties keep total control over the outcome. It tends to be less stressful than going to court, and because it's flexible, it can sometimes even help save a relationship.
But there must be downsides, too.
Oh, absolutely.
Yeah.
Its greatest strength that informality can also be its biggest weakness. Because it's unstructured, it can just fail, leading to wasted time and maybe even higher costs if you end up in court anyway.
Right.
It can also be used strategically as a delaying tactic by one side. And because there's no referee, no decision maker, you might not get a clear winner, which some disputes need. Plus, any agreement reached doesn't set a legal precedent for others.
And this brings up something really crucial, I think, power imbalances.
Yes, that's a major consideration in negotiation.
How does that play out?
Well, one party might just hold more cards, right? Due to their status, their financial clout, maybe even just their personality being more assertive or intimidating.
Or maybe they just think the other side is stronger.
Exactly. There can be an illusion of power where one party backs down because they perceive the other side as having more leverage than they actually do. It undermines the whole idea of a fair negotiation.
And this must be especially critical in certain types of disputes.
Hugely critical, particularly when we look at the impact of gender and power dynamics, for instance, in sensitive areas like family law or domestic disputes.
Right.
If there is what we call an immoral power imbalance, say, in cases involving domestic violence, the fear and intimidation one party feels makes genuine free negotiation pretty much impossible. It's just not a level playing field.
That makes complete sense. So moving along the spectrum, what comes after direct negotiation?
Often, the next step people consider is mediation.
Mediation. Okay, I think I have a vague idea, like bringing in a neutral person.
Exactly. Think of it like maybe a neutral friend helping two other friends sort out a disagreement, or perhaps a trained colleague stepping in when workplace relationships get really strained.
Got it.
Mediation is a process where a neutral third party, the mediator, helps the parties talk, facilitates their discussion. But here's the absolute key difference from other forms. The mediator has no authority to impose a solution on them.
So they guide the conversation, but they don't decide the outcome.
Precisely. The power stays with the parties. Mediation is really focused on problem solving. It's about finding common ground and crafting solutions that both sides can genuinely agree to.
Is it ever required?
In some areas, yes, or at least strongly encouraged. In family law in England and Wales, for example, before you make certain court applications relating to children or finances, you generally have to attend something called a MEAM.
A MEAM.
A mediation information and assessment meeting. It's designed to see if mediation could be suitable for your dispute. There are exemptions, quite a few actually, but the starting point is considering mediation. But what's really vital for mediation to have the best chance of success is that both parties need to be sort of emotionally ready to engage. They need to want to find a solution.
Right. Willingness is key. And the advantages. Similar to negotiation.
Similar in some ways, but with that neutral guidance. So parties still have more control over the settlement than in court. It's usually less stressful than litigation, less damaging to ongoing relationships, which can be crucial in family or business contexts.
And confidentiality.
Yes, mediation is typically confidential. And if it works, disputes can often be resolved much more quickly than through the courts.
Okay, but what are the potential downsides if the mediator can't impose a decision?
Well, that's the core vulnerability, isn't it? Because the decision rests entirely with the parties, a settlement might simply not happen. They might just not agree.
So it could fail.
It could fail. And because the agreement reached isn't usually a court order initially, it lacks that immediate judicial enforcement. You're relying on the parties to stick to what they agreed.
Trust again.
Exactly. Also, the full truth of an issue might not come out in the same way it would with evidence in court. And like negotiation, successful mediation prevents that case from setting a legal precedent.
And the cost issue.
That's a big one. If mediation fails and the parties then end up going to court anyway, it can ironically end up being more expensive and taking longer overall because you've added that extra unsuccessful step.
Right, an extra layer of cost if it doesn't work. Okay, so negotiation is direct talk. Mediation brings in a neutral guide. What's next? You mentioned conciliation earlier.
Yes, conciliation. It's quite similar to mediation in many ways, but there's a subtle but important difference in the third party's role.
Okay.
While a mediator facilitates discussion, a conciliator often takes a more active role in suggesting potential solutions. They actively try to find a resolution and really focus on bringing the parties together, often with the specific aim of restoring or even establishing a working relationship between them.
So more proactive in finding solutions and relationship focused. Where would you typically see this?
It's particularly common, and often very effective, in employment disputes. Situations where miscommunications or misunderstandings have broken down trust, and the goal is actually to repair that working relationship if possible.
Makes sense.
It's also culturally significant in some places. Japan, for instance, has a long history valuing conciliation based on principles of honoring concord and averting discord.
Interesting. And in the UK?
In the UK, the big player is ACAS, the Advisory, Conciliation, and Arbitration Service. They play a huge role in employment disputes. In fact, before you can even bring a claim to an employment tribunal, you must engage in mandatory early conciliation with ACS.
Mandatory.
Mandatory early conciliation, yes. The idea is to try and resolve it before it gets to a formal tribunal hearing. This process can lead to one of two outcomes. Either ACS issues an early conciliation certificate, which basically allows you to proceed with your tribunal claim, or ideally, the parties reach a settlement agreement through ACS. This is often formalized in what's called a COT3 agreement, and that COT3 is legally binding and enforceable. It effectively closes the dispute without needing the tribunal.
Ah, so conciliation can lead to a binding outcome in that specific context.
In the ACS employment context, yes, via the COT3.
Okay. So advantages of conciliation generally, similar to mediation again.
Broadly, yes. Confidentiality is usually a feature. It has that potential to rebuild trust. Parties still keep the option to go to court if it doesn't work out unless a COT3 is signed, and it's generally cheaper and less stressful than court.
And the disadvantages?
Again, similar risks. There might be no clear winner.
Yeah.
Outside of that specific COT3 mechanism, the process itself isn't automatically legally binding. It doesn't set legal precedents. And that same risk applies. If it fails and you end up in court, it could add to the overall time and expense.
Okay, that clarifies conciliation. Now, we touched on power imbalances earlier, particularly in negotiation. That seems like a critical point to revisit, especially when we're talking about these consensual methods like mediation and conciliation.
Absolutely crucial. We need to be really clear here.
Because while ADR offers all these benefits, flexibility, cost saving, preserving relationships, it's just not suitable for every situation, is it?
Definitely not. It's not a one-size-fits-all solution. And this becomes starkly apparent when we discuss highly sensitive situations, particularly those involving domestic abuse.
Right.
Consensual forms of ADR, so negotiation, mediation, conciliation, are widely and rightly considered inappropriate when there are allegations of sexual abuse, physical abuse, or domestic violence.
Why is that? What are the specific reasons?
The reasons are pretty compelling. First, those severe power imbalances we talked about are often inherent in abusive relationships, placing a victim in a room, even with a mediator, opposite their abuser. It's just not a fair or safe environment for negotiation.
The fear factor must be immense.
Exactly. The fear and intimidation experienced by victims makes genuine, free discussion impossible. Second, it's often unrealistic to expect a perpetrator of abuse to cooperate genuinely in a process that requires empathy and compromise.
Good point.
And third, there's the very real risk of further emotional or even psychological abuse through the ADR process itself, just by forcing continued contact and discussion between the parties. In these incredibly difficult situations, the protective framework and authority of a court are often absolutely essential.
That's a really important caveat. So these consensual methods have limits. What about disputes where parties just can't agree or where a binding decision is needed for other reasons? This takes us towards the other end of that spectrum you mentioned.
Exactly. We now move towards the forms of ADR where a third party doesn't just facilitate or suggest, but actually makes a determination, a decision that binds the parties.
Okay, so what's the first one here?
The most well-known is probably arbitration.
Arbitration, heard of it, but what exactly is it?
It's a voluntary process that's key. Parties have to agree to it, where they appoint an independent person, or sometimes a panel, to make a decision on their dispute. That decision, called an arbitral award, is legally binding.
Binding like a court judgment.
Yes, pretty much. It's generally enforceable through the courts, just like a judgment. The whole process in England and Wales is governed by specific legislation, the Arbitration Act 1996.
And why would parties choose arbitration over court?
Several reasons. Lord Hoffman mentioned some key ones in a famous case. Parties often value the ability to choose an arbitrator with specific expertise in their field, unlike a generalist judge. They value the privacy and confidentiality. Arbitration hearings aren't usually public. Speed and efficiency are often perceived advantages too. And sometimes there's a perception of greater neutrality, especially in international disputes.
Sounds good, but are there downsides to arbitration?
Yes. A major one is that the arbitral award is generally final. Your rights to appeal are very limited, much more restricted than appealing a court judgment. Usually you can only challenge it on a point of law or serious procedural irregularity.
So you're stuck with the decision, pretty much.
Largely, yes. Also, while it aims for neutrality, power imbalances can still exist and influence the process if not managed carefully. And that lack of transparency, the fact decisions aren't usually public, can be seen as a disadvantage from a public interest perspective, as it doesn't contribute to the development of law in the same way court judgments do.
Okay, arbitration gives a final, binding decision. You also mentioned adjudication. How is that different?
Adjudication is similar in that a third party makes a decision, but the key difference is that the adjudicator's determination is typically interim binding.
Interim binding, what does that mean?
It means the decision has to be complied with immediately. It's enforceable straight away. But it doesn't necessarily prevent the parties from taking the same dispute to court or arbitration later for a final, definitive resolution.
Ah, so it's like a temporary fix to keep things moving.
Exactly. That's why it's incredibly common, in fact mandatory in many cases, in the construction industry. Think about it. If there's a dispute about payments on a big building project, you can't just have work grind to a halt for months or years while it goes through court.
Right, the project needs to continue.
Precisely. Adjudication provides a quick mechanism. Decisions are often required within 28 days to resolve the immediate issue and keep the cash flowing and the project progressing. It's designed to be speedy. But remember, it might only be a temporary resolution.
Got it. Speedy, interim. What else is there in this binding category?
There's also expert determination.
Expert determination. Sounds straightforward.
It is, in concept. Here, the parties agree to appoint an independent expert, someone with specific technical knowledge relevant to the dispute to decide the issue.
So, not necessarily a lawyer.
Often not a lawyer, no. It could be an engineer, an accountant, a surveyor, an IT specialist. Depends on the dispute. It's particularly useful for resolving highly technical questions, like, was this complex IT system installed correctly according to the contract? Or what's the fair market valuation of this particular property or business?
And the expert's decision.
Like arbitration, the expert's determination is typically binding on the parties, at least until or unless a court decides otherwise later. Though challenging an expert determination can also be difficult. It's usually confidential, and because the expert brings their specialist knowledge, it can be much quicker and cheaper than trying to educate a judge or arbitrator on complex technical matters in court or arbitration.
Okay, so arbitration, adjudication, expert determination, all ways to get a binding decision outside of court. It feels like the ADR landscape keeps changing, though. Are there newer approaches, maybe hybrids or digital methods?
Absolutely. The field is constantly innovating. There are several other interesting approaches worth mentioning.
Such as?
One is early neutral evaluation, or ENE.
Early neutral evaluation. What's that?
This is where an independent, neutral third party, often an experienced lawyer or retired judge, looks at the case early on and gives the parties their expert opinion on the merits. They'll advise on the likely outcome if it went to court.
But it's not binding.
No, the evaluation itself is non-binding. But it gives the parties a realistic, objective assessment of their strengths and weaknesses. It's designed to inform their negotiations and potentially encourage settlement by managing expectations.
Can the court make you do it?
Interestingly, yes. A Court of Appeal case, Lomax v. Lomax, established that courts can order parties to engage in E&E even if one party doesn't consent. It shows just how far judicial attitudes have shifted towards encouraging ADR mechanisms.
Wow. Any downsides?
The main potential downside is cost. If the E&E doesn't lead to a settlement and the parties still end up in a full court battle, it just becomes another layer of expense.
Right. What else? You mentioned hybrids.
Yes, a fascinating one is MedArb.
MedArb, mediation arbitration.
Exactly. It combines the two. Parties start with mediation. If they manage to resolve everything, great. But if there are issues left unsettled after the mediation phase,
Then what?
then the same neutral third party switches hats, becomes an arbitrator, and makes a binding decision on those remaining unresolved issues.
The same person. Does that work?
It has potential advantages. There's a strong incentive to settle in the mediation phase because the parties know a binding decision is coming one way or another. The neutral person is already familiar with the facts from the mediation, which can save time and cost in the arbitration phase.
Any other benefits?
It can allow for face saving, which is culturally very important in some parts of the world, like China. Parties can settle some issues collaboratively in mediation, then have the harder points decided by the arbitrator without anyone feeling like they completely lost. Plus, MedArb awards can be internationally enforceable under things like the Singapore Mediation Convention.
But risks, too, I imagine, with the same person doing both roles.
Big potential risks. The main one is impartiality. Can the mediator, having heard confidential information during the mediation caucuses, truly remain impartial when they switch to being the arbitrator?
Yeah, that seems tricky.
It is. It opens the door to challenges based on bias. Parties might also be less candid during the mediation phase, knowing that what they say could influence the arbitrator later if mediation fails. There's also potential for tactical game playing.
Okay, MedArb. Interesting, but complex. What about the digital side? How is technology changing ADR?
That brings us to online dispute resolution, or ODR. This isn't really a separate type of ADR, but rather using information technology to conduct traditional ADR processes, negotiation, mediation, even arbitration online.
So doing it via video calls, dedicated platforms.
Exactly. Using emails, web platforms, video conferencing, AI tools sometimes. The huge advantage is that it overcomes geographical distance. Think about disputes arising from online shopping, where the buyer and seller are miles apart.
Right, you can't easily meet in person.
ODR makes resolution possible. It's crucial for e-commerce and also for access to justice generally, especially if the nearest court or mediator is far away. A massive example is eBay. They use a third-party ODR provider, SquareTrade, to handle literally thousands of buyer-seller disputes every single day.
Wow, okay. And one more category sometimes mentioned is ombudsmen. How do they fit in?
Ombudspersons, yes. The term comes from Swedish, meaning legal representative. These are independent bodies or individuals who investigate complaints from the public about organizations, primarily public services, but also some private sectors, like financial services or legal services.
So they investigate complaints.
Yes. Typically, after you've already gone through the organization's own internal complaints procedure and you're still not satisfied, they investigate allegations of maladministration or malpractice, basically. Was the service poor? Was the process unfair? Did the organization follow its own rules?
Can they force the organization to change its decision?
Generally, no. They don't usually have the power to overturn a decision made by, say, a government department. But their findings and recommendations carry significant weight. They investigate thoroughly and can persuade organizations to apologize, pay compensation, or change their procedures. Their power lies in their independence and the authority of their reports.
And are they used a lot?
Huge volumes. The UK's Financial Ombudsman Service, for example, handles hundreds of thousands of inquiries and complaints each year. The Parliamentary and Health Service Ombudsman deals with tens of thousands concerning government departments and the NHS. There's also the Legal Ombudsman for complaints about lawyers. They generally operate on principles of being open, fair, independent, effective, and using plain language.
We've covered such an incredible range of options there, from just, informal chats between parties, right through to these formal binding decisions made by arbitrators or experts, plus all the online tools in Ombudsman.
It's a huge landscape.
It really is. And it's so clear that alternative dispute resolution has genuinely transformed how civil disputes are handled. Knowing about these different methods feels really empowering, doesn't it? For individuals, for businesses.
Absolutely. And that word alternative, as we discussed right at the start, it feels increasingly like a misnomer, doesn't it?
Yeah.
These methods aren't just side options anymore. They are becoming integral, sometimes even the primary way disputes get resolved.
Yeah.
The key takeaway, I think, is understanding the differences. Knowing the nuances of each type. Is it binding? What's the process like? Is it suitable for this specific kind of problem?
Yeah.
That's what allows you to make informed choices.
Definitely. So thinking about everything we've explored, this vast spectrum of ADR, from collaboration to binding decisions, and that constant tension between accessing the formal justice system and finding efficient, workable solutions. Here's a final thought for you, the listener. What kind of dispute in your own life, maybe big or small, could potentially be better served by sitting down for a conversation with a neutral third party rather than heading straight for confrontation or formal action?
It's worth reflecting on, isn't it? The potential for more creative, more collaborative ways to resolve conflict is often right there if we just know where to look.